Okay, Attorney Del Campo, could you just take the roll?
Yes, Your Honor. Your Honor is here. Judge Armada,
Present.
Judge Chaplin,
Present.
Judge Green,
Present.
Judge Maturowski,
Present.
Judge McLaughlin,
Here.
Judge Pearson,
Present.
Judge Prats,
Present.
Judge Stewart.
Here.
That's it, Your Honor.
We have a full house. I appreciate everybody making it to this meeting. Attorney Fisher, could you please turn off your camera? I can't, you're muted if you're trying to say, okay. All right. So I will call the meeting to order. The first item on our agenda is 0226, which is the approval of the minutes from our February 26th meeting. Is there a motion to approve?
So moved.
Is there a second?
Second. Second.
Thank you. Are there any changes or modifications to the minutes? If Attorney Del Campo, did you have anything?
No, Your Honor.
Okay, then all in favor, please raise your hand. That passes unanimously.
I'll
I didn't
abstain.
I didn't see Judge McLaughlin's hand. That's an abstention.
Yeah. I'll abstain. Yeah.
Okay,
Yes, and Judge Maturowski will abstain as well.
okay. So the first item then that we'll take up for business is 2023-002, proposal to amend the MCLE Rule 2-27A. Attorney Del Campo, do you have an update for us?
Yes, Your Honor. This was on last month. It was tabled into this month to allow, I believe, another moot court to happen, and Judges McLaughlin, I believe, and Armada to relay their experiences, having, I think, judged some of the competitions or attended the competitions, so you wanted to hear from them.
And I saw Judge Armada here at the Supreme Court last week, so I'll turn to him first.
So first off, I want to congratulate Jonathan and his team, and the future of our profession. When you look at these kids who are at the high school level, was just incredible. And the excitement that it brings to a courthouse. I was fortunate enough to be a judge in the New Britain Judicial District, and to see the parents, the teachers, the students just so engaged and wanting to understand about the law and civics education. I know that, the question becomes, do we give CLE credit for it? And I know that the Standing Committee on Mandatory CLE has some reservation about it, but I found it a very worthwhile experience. I guess the question becomes for lawyers, is it really exercising continuing legal education? But they are given problems, civil, criminal, rules of evidence they have to apply. And I question, the difference between this and a law school or this and a college type thing. So that's my thoughts on it. I pass to Stephanie. Judge McLaughlin.
I echo what Judge Armada said as far as congratulating Jonathan. I thought it's a lot of teenagers, so it can get very unruly, but it was very well organized. And I thought the problem that they put forward to the participants was very interesting. I agree. I thought it was, it's an opportunity certainly for the bar to participate and encourage young people to be involved in the law and civics. And I thought that was very clear. They were all very engaged, all very well prepared. And I think I have the similar comments as Judge Armada, as far as I know that the question for MCLE has been, whether or not that's something that's encouraging attorneys to perfect their craft is a question. But I agree. I thought it was a very, as Judge Armada said, a very worthwhile endeavor.
Thank you. Judge Green, actually, I also see Judge Gold has his hand up. I don't know if that's intentional or if you want to speak to this item or not, but I'll turn to Judge Green first.
You're on mute,
You're
Your
muted.
Honor.
You're muted.
I apologize. Apologize for being muted. And I apologize for not mentioning it at the last meeting, but on February 25th, I was a judge at the Regional Collegiate Mock Trial Association competition at Conn College. I was there all day Sunday. I echo the comments of my colleagues, but I would just indicate that judging in a mock trial competition it's a lot of work for the judges. The amount of preparation to answer their objections in real time, to think through the law as they're thinking through the law. I was exhausted by the end of the day, and I was just one of many judges who were working very hard. So attorneys from all different kinds of practice. There were judges who were there, sitting judges, seated judges, retired judges. It was an impressive endeavor. And I'm not sure what ultimately the committee will decide, but certainly it was a lot of effort on everybody's part.
Thank you. Judge Gold, did you want to address this item?
Not this item. I was hoping to weigh in before we got started. If there's any, I don't know where I am on the agenda today on the uncharged misconduct rule, but if with everyone's indulgence, if I'm toward the bottom, if I could be moved up, I'd be most appreciative of that.
We'll take you next, actually, then.
Thank you very much.
Okay, Judge Pearson.
Yes. So I have served as a judge at in both high school and collegiate competitions, and I can tell you, I want to echo the sentiments of everybody saying it's a very worthwhile endeavor. It takes a lot of planning and preparation to do these mock trials for everybody involved, and I think it's a wonderful process and a worthwhile process, and it should be part of, it's a wonderful part of our civics education, and all of that. Putting that aside, my concern is not so much that it is or is not a worthwhile endeavor. It's whether we should allow attorneys to get credit for this type of work. And I happen to share the concerns of the MCLE Commission when it comes to the intellectual rigor of the programs and how worthwhile they are in terms of continuing legal education. And I say that without casting any aspersions on the process itself or the importance of mock trials to a young person's enrichment and education. But I happen to think it should not be allowed in terms of credit for CLE. That's my view.
Thank you. Judge Armada.
So I want to put forth that if we don't do this and allow lawyers to get credit for what they've got to have for continuing legal education, if lawyers stop being judges, what does this do to this feeder program, not only for civics education, but to create young minds and future lawyers down the road? If a judge is saying, look, I'm giving up, and I think the time is like from 2 to 5, 3 hours, plus the prep time before to read the problem and things like that, what will that do to this program? And if this program dries up because they can't get qualified judges, what does that do? Number two, we are allowing for MCLE credit in certain other collegiate judging and law school judging type thing. And I question, is it the age? I have the utmost respect for the MCL Commission, and that's why I'm struggling with in terms of why they're saying no in terms of that, and where's the differentiation between a high school program, a college program, a law school program, and again, what would happen if we don't sanction this? I just raised those questions.
Thank you, Judge Pearson.
Well, just to respond to Judge Armada, I don't think that the programs are rising or falling based on whether they've never been. We've never given CLE credit, allowed it before, and I'm not sure there is a relationship between giving the CLE credit to people and having these programs either succeed or fail. I have no doubt that probably there might be some more participants if we do allow the CLE credit, but I'm not sure that it is ipso facto that it follows that if we don't allow it, that these programs will fail. And I think we should be focused on keeping our standards as high as reasonably possible. And my next question is, does this lead to one of the issues I see too, is this a slippery slope? And then we start doing junior high school competitions and so on and so forth. So I'm opposed along with for the reasons outlined by the MCLE Commission. That's all I'll say. Thank you.
Thank you. Judge Green. You're muted.
I'm always muted. All right. So I just wanted to mention that, I mean, as a state, I think we're relatively new to CLE. So I guess the question that I had was, do other states allow this? I mean, if we are to be the only state that allows individuals to get credit for the mock trial, then certainly that makes sense to me. But I agree with Judge Armada. I certainly understand Judge Pearson's position. I think that for a lot of litigators who, I think the civil litigators, I think are in court certainly more often litigating than some of the other disciplines. But to have the experience of like responding in real time to folks who are prepped and objecting, I think it's a good experience. Again, I'm not sure what my position ultimately would be, but I'm wondering if we're in some uncharted waters with this suggestion, or whether other folks have done it as well. And if I missed that along the way, I apologize.
No worries. Before I recognize Judge Matrowski, let me make sure everybody's looking at the same document that I'm looking at, which is 2023-002F, which has the revised language in it on page 2. And to be clear, we already allow attorneys to receive CLE credit for serving as a judge on a moot court or mock trial competition in a law school. So this is really just would be extending it to a different level for high school competitions. So I wanted to make sure that was clear to everybody. Judge Matrowski.
Yeah, and you kind of went where I was headed. I wanted to make sure I was looking at the right current proposal, which as I read it, is for high school or undergraduate, and it's limiting to just, 2 hours would have to be actual judging or coaching. And there's also, I think, a footnote describing the other states that do have similar rules, and it specifically caught my attention. That includes New Jersey, New York, Rhode Island, Vermont in our area, as well as some other states, Oregon, Colorado. So I don't think we're plowing new ground here. And I do think there's precedent from other states, including some of our sister states in the Northeast for doing this. So, and I think also it has to be accredited by the American Bar Association or an approved state bar examining committee. So to me, they're kind of sufficient guardrails there to make sure that the quality and seriousness are sufficient to warrant some recognition, and also the recognition is still somewhat limited. So it's not like you're going to be able to bypass all continuing education by doing this. So I think based on what I've heard, I'm inclined to support it, but that was my thoughts.
Okay, thank you. I think nobody's suggesting that there is not. Attorney Podolsky, if you could turn your camera off, thank you. That there is not a lot of merit to this. I think the MCLE is just concerned about every year somebody is looking for another aspect of this to be extended to them. So I think there's some larger institutional issues that they are concerned with. But I think we should also, we've had this on a number of times. I think we should probably put it to a vote. And Attorney Podolsky, please keep your camera off if you don't mind. So we should put this to a vote and let the chips fall where they may. Is there a motion to approve this item?
So moved, Judge Kratz.
And is there a second?
Second.
Second, is there any further discussion? If not, all in favor, please raise your hand. Opposed? So that is, did you catch that? I think we have just Judge Pearson and Judge Chaplin in opposition. Is that
This
correct?
is Judge.
Oh,
This is
Stewart.
Judge Stewart. I'm abstaining. I sit on the Minimum Continuing Legal Education Commission, so I abstained there and I'm abstaining here.
Very good, with one abstention. All right, you have that vote, Attorney Del Campo?
Yes,
You're
Your
muted. There you go. Okay.
Yes, Your Honor, I have. Thanks.
Okay, thank you very much. Get
So
myself
that will
back.
go to public hearing then.
Correct.
Okay.
Yeah, for people who are listening, just so you know, just because we've taken this vote, it's not a final vote. We will have our public hearing in May, and then we will have our final vote on all of the rules that we've passed on on a preliminary basis in June, so that we have our when we have our annual meeting in July, all of the judges will have an opportunity to weigh in on any proposed rule changes. Now, I believe Judge Gold is here on item 2023-023. I think that's why Attorney Fisher is here. I don't know who else might be, whether anybody from the, is Attorney Lawler on? If Attorney Fisher and Attorney Lawler, oh, Attorney Baer.
No, Attorney Baer.
All right. Let me, hold on, make sure I'm looking at the right thing here. Okay. So just by way of background, you will remember from our last meeting, we urged the working group to get together, a working group comprised of representatives of the Office of the Chief State's Attorney, the Office of the Chief Public Defender, and the Criminal Defense Lawyers Association, to get in a room and get a proposal that could be considered by the committee today. And I am told that all of the parties who were in those negotiations have agreed on language that is reflected in the communication that was sent to you from Attorney Baer. It's attached to her March 13th email. And I think I had asked them to share that language with Judge Gold. So I will turn it over to Judge Gold to hear any comments he has on the proposal.
Thank you, Justice McDonald, and thank you to everyone for allowing this matter to move to the head of the class. I just wanted to express my thanks to everyone on the working group for coming together to put together a rule that we can adopt. I see very little to comment on. I will therefore just identify the one question I have about the rule, and it's in the very last line of the rule itself. It indicates really in that last paragraph that if there does exist a variance between the offer of proof and the state's disclosure, that the evidence would still be admissible if the court determines that the variance is immaterial and has not unfairly surprised the defense. My only question was what purpose the materiality language serves. And I guess by way of example, if there is a variance which does not surprise the defense in any way, but it is material, is it the intention of the parties that the court would exclude it, even though the defense did not suffer any unfair surprise? So
why don't I ask Attorney Baer to address that first, and then Attorney Fisher. You're muted.
My apologies. Thank you. I'm Katie Baer. I work with the Division of Criminal Justice. Thank you, Justice McDonald and Judge Gold, for looking at it. originally I think it was contemplated as a prior draft had contained actually a sort of a three-prong finding. I think it was the vision of, at least from our point of view, that the proffer would have to satisfy both prongs, in that it would have to be both immaterial and not cause any unfair surprise. But to be honest, I don't know in our discussions whether we actually bandied that about. So I'm open to what Attorney Fisher has to add. And I know also Attorney Bourne is on the call as well, and she participated in these discussions.
This is Attorney Fisher. I'm not sure I know how to figure out how to turn my camera back on, but I'm here. If you can, I'm afraid if I turn it on, I won't be able to turn it off. I agree with Attorney Baer. I don't think we really focused actually on that good point that Judge Gold raised. I think the issue is really just that if it's an immaterial difference, what we were looking at, then that would not be cause for exclusion. But certainly we were focused on the issue of surprise. I don't know that the working group would have an objection to say and or, but I think the real key is that there'd be no surprise to the defense by a late disclosure. I don't know if Jennifer Bourne would like to weigh in as well.
And my apologies to Attorney Bourne. I didn't know she was on the call. Do you have anything you'd like to add?
Hi, thank you, Justice McDonald. I don't have anything to add to what Attorney Fisher added. I think the key is no surprise or unfair surprise. I do think, and we talked somewhat about, but this could be something trial courts could deal with on a case-by-case basis when there is a variance, how that could affect admissibility. So if a ruling was made on the offer of proof, and then a variance comes up after the fact, how does that factor into the admissibility finding? But I wouldn't have an objection to an and or, as long as there's no undue surprise.
Thank you. Maybe this is a question for Attorney Del Campo. Do you know of any place else in the practice book where we say and or?
I suspect we do. I have Attorney Petrozelli on here who is an expert on this, so maybe she can come on the screen. I do believe we have it. It's probably not preferred, but.
Right, Attorney Petrozelli?
I think Joe nailed it on the head. It's not a preferred convention in the practice book. So if you do find it, it's going to be a rare occurrence, but I believe you probably will be able to find some instances.
Okay.
May I suggest that the word and just be changed to or?
That's what I was thinking.
We don't need the and or. I think if it's immaterial or it has not unfairly surprised the defense, then it could still be admitted.
That's exactly what I was thinking, Judge Gold. Is there any, I'm not looking to prolong this, but any of the stakeholders have any objection to changing and to or in that last line? And I will take silence as acquiescence. Okay, so with that change, Judge Prats, you're muted.
Sorry. I have a question on the one right before the one that Judge Gold was referring to, on the judicial cause for a good cause for late filing. That last sentence, when late notice is provided upon a finding of good cause, the court should implement measures to ensure that defendant is not prejudiced by the late disclosure. What if he's prejudiced, but the evidence is more, probative? I don't like, how can a judge ensure that he's not prejudiced necessarily by that late disclosure? I mean, they say measures, but it's up to the court. I mean, the court is going to try and balance this late disclosure, but it may be somewhat prejudicial, but it's still more probative, and it will allow it, or she. You know what I mean?
So I was not involved in these discussions, so let me do it in the same order that we did it previously. If Attorney Baer first. Do you have any comment to Judge Pratt's question?
My comment is that sentence was the suggestion of my good colleagues at the Office of the Chief Public Defender. So, the state was willing to agree to that sentence, but I can see what the judge's saying with respect to that balancing. So I'll let my colleagues address that.
All right. Actually, let me switch that up and go to Attorney Bourne next.
Thank you, Justice McDonald. So I think that sentence was intended to have more to do with a remedial measure for the late disclosure as opposed to an admissibility finding. So when Your Honor is saying, that it would be more probative, I'm hearing like an admissibility finding. And this really is just to ensure that the court should take action to make sure when there is late disclosure, and whether that's granting a continuance or some other kind of measure. I mean, I think continuance will be most of the time what the measure is, but I don't know if under circumstances defense might request something else. So the defense isn't prejudiced by the late disclosure.
And I'll ask Attorney Fisher, as the proponent of the rule, if she has any comment.
Yes, thank you, Justice McDonald. I did two comments. One is just to echo what Attorney Bourne said, that this wasn't intended to be a limitation on admissibility, but rather was to try to ensure a lack of surprise to the defendant. And I would just add as a second point that this language actually comes from the advisory committee notes to the federal rule, which has this proviso in it, really in the same language, and I think it's been adopted by at least one other state, I think Pennsylvania. So the idea is really just to try to minimize, if not eliminate, surprise to the defendant.
Thank you. Judge Prats, did you have any follow-up questions?
No, thank you.
Oh, okay. Why don't we do this as a formal motion? Understanding we're changing that last word from and to or. Is there a motion to approve this item?
So moved.
Is there a second?
Second.
Thank you. Is there any further discussion? If not,
Your Honor, can I say
Yes.
one thing, please?
sorry.
So this is very technical, but it needs this new rule will need a number. We can assign it a number, which we thought would be in chapter 40, 13-B. It seems to fall properly within that series of rules. And that can be changed, but we'll assign a number to it, and it'll need a commentary. And I would just simply suggest a simple informational commentary, like the introduction to this that is on the agenda. So I can insert that, and you'll see it in the minutes if that's okay.
That's fine. That's fine. I appreciate that. Okay. All in favor, please raise your hand. Opposed? That passes with, I believe, just Judge Chaplin in opposition. Is that right?
I was just late in the affirmative.
Oh, okay. Then that passes unanimously. Let me just say thanks to Judge Gold and to the whole working group. I really appreciate their professionalism and working on a fairly expedited basis to address this issue. Thank you very much.
Thank you very much.
Thank you.
All right, then let's go back to 2023-008, the proposal to amend various practice book sections regarding the pathways process in family matters. And I believe Judge Diana, there he is, right on time. I believe he comes to us with good news. Judge Diana.
Good afternoon, Justice McDonald. Good afternoon, members of the committee. I am proud that after we met again with the stakeholders, that the proposed rules are not being opposed. And I just basically have a brief statement. This transition into pathways has been begun nearly 4 years ago during the height of the pandemic. We've consulted with the National Centers for State Courts and listed the development and implementation of the process. Judge Bizzuto, Judge Albus, Judge Facito, and even the Chief Justice have been committed to finding ways to improve the process of how cases are handled in the family court. Pathways addresses major concerns that were raised in the earlier satisfaction survey, including the amount of time spent waiting in court and too many court appearances. process was cumbersome and a poor use of resources. The system allows the court for better manage its docket and provide cases with the services they need. Pathways treats each case uniquely instead of having a one-size-fits-all system. 3 tracks are available to determine the next steps for the case. A track A for cases that require little or no court intervention, track B that requires some court involvement, and track C for cases that require significant court involvement. Access to court is available at multiple points in the case. The resolution plan date, case date, motion docket, assigned hearing dates for longer, more complex matter, and the parties can have a status conference or pretrial with the judge. Also, trial dates are scheduled earlier, giving parties knowledge up front of when their case is expected to be over. Scheduling orders are also issued by the court, and a path of the case is clear for everyone. Every court follows Pathways model with variation based upon the volume of cases in that jurisdiction, the resources available, including the number of staff and judges. However, parties always have access to the court if a hearing is needed. If the parties cannot wait until the next scheduled event, case flow requests can be filed asking for the matter to be set down for an earlier date on a motion docket. The proposed rules have been shared with our stakeholders from various legal organizations. We've listened to their concerns and have made several changes as a result. What we've avoided doing is making changes that could compromise the effectiveness of Pathways. So I am pleased to report that they do not oppose the rules as drafted, and I'd like to specifically thank Bonnie Amendola of the Connecticut chapter of the American Association of Matrimonial Attorneys, Aidan Welsh of the CBA Family Law section, and Attorney Podolsky of the Legal Services Programs. He has been their spokesman. Finally, I'd like to make special thanks to a member who's sitting on this committee, Judge Elizabeth Stewart, for her wisdom, insight, and organization. And all of her comments have been incorporated into the final version. These proposals are sound, and I would request their adoption. Thank you.
Thank you very much. And let me also add my gratitude to Judge Diana and before him, Judge Albus. I don't think he's on this, but I would appreciate it if you would share that with him, Judge Diana. This has been a long time coming. It's been a contentious process, but I do really appreciate everybody coming together and working on a solution. I like the way Judge Diana framed it, that there's not opposition to it. I can't, from what I've heard, it's not being embraced like perfection, but I appreciate the practitioners bending as well to help the judicial branch achieve its goals with this system. I do think that it's important to note that this is giving some uniformity to a practice, to a very important area of the law that has been treated unevenly in different jurisdictions, and we need some uniformity in the way that we approach these things. And I have talked to some of the practitioners and shared with them that we need to get this done. I think this is a good place to codify this in our practice book. It's not to say that with time and experience, it can't be revisited or tweaked in the future. But it's important that we have the uniformity so that practitioners and self-represented parties can have a clear place to understand what is going to be expected of them and what their options are. So having said that, let me just ask Judge Diana, on page 3, first of all, we're dealing with 2 different items, I want to be clear, but one is letter N and one is, we'll get to O as well, but on N regarding sections 25-34 and 25-50, on page 3 of that document, at the bottom in the commentary, the last sentence says a subsection H was added. I don't see a subsection H.
Well, as recently as 1 o'clock, Judge Stewart noticed that also, and we made some minor changes to the commentary, and she had spotted that. I'm sorry I missed it, but she spotted it and we made some changes. So I sent that over to Joe it was probably 1:30 by the time we got it changed and sent over. So that will be corrected, or has been
That's
corrected.
fine. And the commentary isn't as significant as the rule, so we can move forward without that. But was there any other significant change?
No, sir.
Now, let me
Your
just
Honor.
make a little clearer about the commentary. F is really the H that's referred to. And for that matter, I suggested to Judge Diana that everything from language was added just be dropped because all those references are off. Like I'm sure they were correct several versions ago, but they're no longer accurate. And I don't really think they add a lot of value. The first couple of sentences are the important ones in the commentary. So that's the version I believe that was sent to Attorney Del Campo at 1 o'clock doesn't have those last couple of sentences to begin with. Language was added.
The good news is our legal staff protect us from ourselves. And so I am sure they will catch all of that for the official commentary. Attorney Del Campo, do you have anything?
No, it's just those last two sentences that'll be taken off the commentary. So I do have that. Right.
Okay. All right. Having said, Judge Stewart.
One other thing I just want to bring to principally Attorney Del Campo's attention, but everyone's attention, I guess, for both 2534 and 2550, these are really overhauls, but the redlining you see here is not redlining from what's in the practice book right now. That's redlining from like the last version you guys saw. So I just want, people to realize, because obviously what goes out to the public before our public hearing and everything needs to be a different red line for those two sections.
I understood that, but I'm glad you've mentioned it. That I think the whole thing is new language that for purposes of the public hearing. Is that correct?
Yes.
Pretty much.
Okay.
We will check that. We have other editorial technicalities to check on, so we will do all of that before the public hearing. Thanks.
Judge Armada, is your hand up, or well, I see it up? Okay. All right. So because I want to do this in two parts, then the first would be a motion to approve 008N, the supplemental revisions to sections 25-34 and 25-50. Is there a motion to approve?
So moved.
Is there a second?
Second.
Is there any further discussion? With gratitude to everybody, all in favor, please raise your hand. Any opposition? That passes unanimously. Then let's do a separate motion for the correction, item O, the correction to proposal section 25-51. Did you want to mention anything, Judge Diana? It looked pretty self-evident.
Yeah, I believe it is. Thank you.
Okay. Then is there a motion to approve?
So moved.
So moved.
And is there a second?
Second.
Any further discussion? All in favor, please raise your hand. Any opposition? That passes unanimously. Congratulations, Judge Diana, and please again tell Judge Alvis we appreciate everything he has done to get us to this point today.
Thank you very much. I will. Is there a way that the Parentage Act issue could be moved up or not?
I would be happy, since you delivered a result here on this complicated issue, I'll be happy to take that up as well. I should note that Judge Wynne O'Dowd, you're just joining, right? I didn't see you earlier.
I've been here waiting for Judge Diana to finish with the Parentage Act. That's first in time.
Okay. So the Parentage Act is 2024-002, the proposal to amend various practice book rules mandated by the Parentage Act, which was a public act passed in 2021. Judge Diana, did you want to address that issue?
No, on our side, it was really just some language changes to parentage. So it really didn't affect any of the material language in the practice book.
Yeah, it looked like it was all conforming language. Did anybody have any questions on this item? Attorney Del Campo?
Yes, Your Honor. We noticed that in one of the rules, 25-1, there was language proposed to be removed, which if you look at it, it's the brackets around or civil union. I discussed it with the attorneys here in legal services, and subject to Judge Wynn O'Dowd's approval or acceptance, we think that should remain in because of the foreign jurisdictions, civil unions that come into Connecticut and may need to be have a legal separation or dissolution. That language, I think, should remain in, but certainly Judge O'Dowd should speak on that. I hadn't had an opportunity to speak with her about it.
Attorney Del Campo, is that in definition section 25-1 for family matters or 26-1 for juvenile matters?
I'm sorry, 25-1 for, I guess it would be family matters, yes.
So I think that's probably
Judge
directed to
Diana.
Judge Diana.
That's fine with me.
It's in several times. This is the only time it's taken out. So we decided that that was not the intent of what was happening here.
So
So-
it's not a big issue, but my, at least in Connecticut, when the Kerrigan decision was codified in statute, there was a automatic conversion of civil unions into marriages in Connecticut. Are there states outside of Connecticut that still maintain the distinction between marriages and civil unions?
That's what I understand, Your Honor. Yes, and that's why it's been saved in these rules. And it's in a statute or two as well.
Okay. Okay. Is with that understanding, is there a motion to approve this package for the Parentage Act?
So moved.
Is there a second?
Judge Pratt, I'll second.
Thank you. Is there any discussion? Hearing no discussion, please signify yes by raising your hand. Is there any opposition? That passes unanimously. Thank you very much, both Judge Diana and Judge Wynn O'Dowd. I appreciate it.
Thank you. Take care.
Next item is 2024-003, the proposal to amend practice book section 3-10B to reflect current practice with remote hearings in civil and family matters. Attorney Del Campo? This is
Your Honor.
from Judge Bellis.
Yes, it was on last month. There was some discussion about the language being confusing. This iteration of the language separates out subdivision 3, makes it, I think, clearer. Is it yes, it makes it clearer that the party can, if it's a remote hearing, the party can show up remotely. If it's a hearing in person, the party can show up in person.
To be clear, we're talking about the revisions contained in 2024-003C, correct?
Yes, we are, Your Honor.
Okay. So I appreciate that. Let me just say, somebody, not in the context of this proposal, but in general, and this may be something we want to look at for next year, that there are a lot of remote hearings that are being conducted on pretty substantive materials or motions, I should say, and that there has been an expression of regret from some practitioners that younger attorneys are not having the experience of getting into courtrooms and standing before a judge, standing on his or her feet and taking the arrows from a judge, and it can't be replicated on a remote hearing like it is in a courtroom. And that is something that really did resonate with me. We may want to look next year at putting some parameters around what can be handled by remote hearings or status updates or something like that versus substantive motions that might even require evidentiary hearings. So it's not really something for us to do today, but I will acknowledge, since I opened the can, to ask Judge Pearson for his comments.
I'm not, I don't particularly want to comment or open a can of worms, Justice McDonald. All I'll say is please sign me up for that job. And I have written, I have prepared a writing to the Chief Court Administrator, which I sent a few years ago about in-person versus remote and the issues and problems that arise. And I'd be happy to share that with anybody who might be interested, including yourself.
That might be a good launching point for us in September to, after we have our final meeting in June, maybe you can circulate that and we'll use that as a launching point for a discussion. Judge Chaplin.
I'd be happy to do it.
Just a quick note too, just recalling this becoming part of our common practice after the Supreme Court issued a decision regarding termination of parental rights proceedings and how that would apply, and that may be the place where the conversation begins, and the discretionary nature of that may be more critical than prohibiting it altogether.
Good point. Okay, so having said that, the proposal that we are looking at is as referenced in item 003C. Is there a motion to approve?
So moved.
So is there a second?
Second.
Okay, let me acknowledge Attorney Del Campo first.
Yes, Your Honor, my apologies, but this should be considered with the prior draft, that at least the commentary from the prior draft. The new language was amended, but it doesn't have the commentary attached, but that would come from the original proposal, same commentary.
Understood. Thank you. Judge Stewart. You're muted.
I was trying so hard to be good about that. I apologize. So first of all, I want to acknowledge the revision that was made. I had that concern about the ambiguity, but I have a remaining concern. I had two of these in front of me today, and I had this happen repeatedly, where the lawyers, when they file the motion, they actually comply with these requirements, but they don't know when the hearing is going to be. So they leave all blanks, which is not at all helpful. Then the hearing gets scheduled and the lawyers show up, usually remotely, but either in person or remotely, and there's no client there because the client doesn't have the slightest idea. So as terrific as this rule change is, and I'm a huge proponent of it, I would like to revise it further to provide that if the hearing has not been scheduled at the time that the attorney files and serves the motion and notice, that the attorney shall serve the party with a revised notice that provides the information required by numbers 2 and 3 in advance of the hearing. I can't tell you, I'd say 2/3 of these things that show up in front of me, I have to kick them out because they haven't let the client know how to participate. So I don't think this completely solves the problem as written right now.
So did you want to do that as an amendment to the motion?
I would like to do that as an amendment to the motion.
Just so we're
obviously,
clear.
Judge Bellis, as the principal author, should have some input, and I apologize. It just, as I was reading this at lunch, I was like, this still doesn't fix the problem.
Just so we're clear, can you give us your exact amendment? I want to make sure our staff have the
So
language.
I would add to the very end of subsection B as in boy, if the hearing has not been scheduled at the time that the attorney files and serves the motion and notice, comma, the attorney shall serve the party with a revised notice that provides the information required by 2 and 3 above in advance of the hearing.
Is there a second on that amendment? It's seconded by Judge Pearson, I think.
Thank you. Yes. Sorry, I was muted, but I do second that. And it's a very excellent point by Judge Stewart.
Okay. Judge Chaplin, did you want to talk about the amendment or were you?
I had another comment. On the last meeting, I made a request or a comment regarding an amendment and speaking with Judge Gold, but upon further reflection and speaking with Judge Gold and just reviewing it again, I'm withdrawing that because it's already covered by subsection C for the criminal matters.
Okay, Thank you. All right, so what's before us right now is Judge Stewart's amendment. Is there any discussion on that amendment? If not, all in favor of the amendment, please raise your hand. Opposed? That passes unanimously. Back in the old days of, okay, now the motion as amended. Is there any discussion on the main motion as amended? If not, all in, Judge Green, did you, or are you just voting early? Okay.
I'm good, thank you.
Okay, so all in favor, please raise your hand. Opposed? That passes unanimously. All right. Next is 2024-004, consideration of section 21-25 concerning the applicability of sections 21.1 through 21.24 on receivers. Attorney Del Campo.
Yes, Your Honor. This was this rule was new last year. It was in response to the Uniform Commercial Real Estate Receivers Act, which was passed, which was effective July 1 of 2023. I did, in my capacity, get comments from Attorney Dennis Karen, about whether or not there should be rules. The Rules Committee talked about this. Judge Bellis, I think, did have a conversation with the CBA. No rules were presented in time for that July 1 date. We had suggested that this kind of rule be recommended and for adoption, such that it basically says, except as otherwise provided by law, including this Uniform Act, these rules shall apply to receivers. So we had hoped that, or the committee had hoped that there would be no conflict, or if there was a conflict, then the court and the litigants would be able to sort it out, because until that amendment, until this new rule, there was no understanding of what the applicability of the rule versus the statute would be. But Your Honor had recommended that it would be effective for 1 year only, which after promulgation, which was June 20th, 2023. So this rule now runs out June 20th, 2024, unless further extended. So what you have today is the rule and consideration of whether or not it should be recommended that it be extended. There are no rules pending with the Rules Committee that change the practice book in terms of receivers. None have been forthcoming to date. So the question today for you is whether or not you want to recommend to the judges that they extend this rule. I do believe it has to go to public hearing, so that's why you have it today, so that it can go, if you choose to go to public hearing.
Okay, I'm trying to remember what happened way back then. Are you making a recommendation that we extend it for a certain period of time or indefinite period of time?
I would recommend that you just have it extended for just have it extended indefinitely. Have it become its own rule for whatever period of time it needs to be, and then if you have a rules proposal from whomever, then you would just, like any other rule revision, you make the changes to the practice book. This at least allows litigants to know where to go. I mean, there are many instances of the rules saying, unless otherwise required by law, the sealing rules do that, many rules do that. So this at least alerts people to the law. It actually cites the law in the rules. There was a huge concern that there would be a conflict and nobody would know how to proceed with the statute and the rules being somewhat different. Yes, I would recommend that it go to the judges without a sunset date.
That makes sense to me. Do any members of the committee have questions for Attorney Del Campo? If not, is there a motion to approve this item with an indefinite date?
So moved.
Is there a second?
Second.
Any discussion? If not, all in favor, please raise your hand. No opposition. That passes unanimously. I said to Attorney Del Campo, I appreciate his staff keeping track of things like this. I would have totally forgotten about it without his reminder. The next is 2024-005, commentaries for various rules. Attorney Del Campo.
Yes, Your Honor. These are rules that somehow got through without commentaries added. Sometimes they just come and it's not clear that the committee's going to recommend them. So some of them, most of them have comments. These did not. I just wanted to make sure that you had comments on every rule that was going to public hearing. So you actually need to consider them and approve them. They are rules committee commentaries. The one addition I would make to that is the MCLE rule that just passed. That doesn't have a commentary either. I would just, if it's appropriate, it would just carry an informational commentary, basically just what it is, that it's intending to do this and have credit for X, Y, or Z. But you need to see these and approve them if they're going to go on. They don't have to go on, but typically all rules have commentaries when they go to public hearing. And then they continue through the practice book as rules committee commentaries.
Thank you. Judge Chaplin.
From reviewing those, there were 3 grammatical changes, well, 2 changes and 1 question I had. Going to page 9 of the commentaries, the first paragraph of that page preceding section 13-32, the paragraph begins the deletion of subdivision 2. And that very last line is should apply remote depositions. I believe the word to is missing before remote. For the second one, page 18.
I'm sorry, Your Honor. Can you say that first one again? I was racing to find it. On page 9, 1332.
It's missing 2 before remote depositions in the 3rd line down.
Okay.
Next, Judge Chaplin.
Turning to page 18, there is a moment trying to find it myself. I have a note that search. So page 18, the second line on the page, subject to the next sentence, the remain changes should be remaining changes.
Judge Chaplin gets the Eagle Eye Award. And next one.
Page 20, I had a question about the paragraph on the commentary, the change to subsection C. There's a comma after the word issue, but I wasn't sure that comma was appropriately placed or if there was another comma missing. So I don't have the change recommended. I just wanted the committee to look at that and see if that punctuation should be changed somehow.
The comma, I don't see, let's see, a comma in the commentary?
Yes, after the word issue. I'm not sure if there should be a preceding comma to set it off as a positive, or if that's to break up the sentence.
What say you, Attorney Del Campo?
I think it causes you to pause, to breathe for half a second to continue in the sentence, but I'm happy to take it up. Oh, Lori's on the screen. Lori, no.
It's
My
an
vote is
awfully long sentence.
no comma.
No comma. Okay. So, okay, with those 3 changes, I appreciate Judge Chaplin pointing those out for us. With those 3 changes, is there a motion to approve these commentaries?
So moved.
Second.
Is there a second? Okay, seconded. Any discussion?
I will
All in
add
favor,
the
please?
FCLE commentary, Your Honor.
Yes, with the generic language. All in favor, please raise your hand. Opposed? That passes unanimously. And I don't think there is anything else on our agenda for today. Is that correct, Attorney Del Campo?
I just want to remind the committee that there is no meeting in April. These rules that you've adopted or that you recommend will go to the Judiciary Committee 35 days before the public hearing, which is April 8th. So on or before April 8th, we'll get them to the Judiciary Committee. Also, the public hearing on May 13th, just a reminder, it's at 10 a.m. as opposed to 2, which is typical of your meetings, but it is at 10 a.m. And I believe Your Honor wanted a hybrid. Are we going to be in person and broadcast, Your Honor, Justice McDonald?
We haven't discussed it. I would personally prefer it, consistent with what I've said before, some things should be done in person. I think if we are going to hear from members of the public, we should do it in a more formal setting where they can address us. So I would personally prefer to do it in person if that is not too inconvenient for members of the committee. Okay, any opposition to, okay, we'll do it that way.
Where would the meeting be? Excuse me 1 second. Where would the meeting be? Do we have any idea?
Probably in the Supreme Court courtroom. That's where we historically did it, right, Attorney Del Campo?
We have, but I think because of the audio-visual issues, I mean, we had it last year in the attorney's conference room, and they had overflow go into the courtroom. But there was an abundance of individuals who had to go into the courtroom.
Yeah, I would like to do it in the courtroom. It was not optimal last year, and it's really the public's one chance to address us. So I would prefer to do it in the courtroom. We hopefully can work out any AV issues in advance. I should also just mention miscellaneously, I am required to send notification to the leadership of the Judiciary Committee that we are amenable to meet with them twice a year, I believe. Historically, they have not taken us up on that. This year, they asked to meet. They didn't want to burden everybody here with trial schedules, so they asked me to just meet with them. Attorney Del Campo joined me, as did Melissa Farley. I would characterize it as a very not happy occasion, but amiable occasion is probably the way to say it. I didn't take away any big concerns. Representative Fishbein had expressed some concerns about the family docket and actually not having established rules. So I suspect he will be pleased to see that we have finally adopted rules for the public hearing to be considered, and we will point that out to him when we communicate with them about those changes. The other thing, Representative Staffstrom, Joe, I'm going to ask you to help me out with the second part of this, but he did raise with me a problem he has seen that he would like us to talk about next year with requests to revise. He said that he has had a couple of experiences where there are contract actions that reference a contract, but that the contract isn't included with the complaint. And judges have been denying requests to revise to ask for the inclusion of the contract because that's not one of the specific items in the request to revise. And he suggested that it might be the result of some judges without a lot of civil experience or tenure who don't know about it and would like us to look at that. It is, I mean, he was clear, and it was my experience in practice, you need the documents attached if you're going to set it up for a motion to strike. And without it, you're stuck with the four corners of a complaint that don't include the terms of the contract, even though it's referenced and incorporated into the complaint. So I told him we would take a look at that. And Joe, what was the other issue Representative Staffstrom raised? Do you remember?
No, I think that was one of his. That was the bigger. That was the
bigger of the two. Yeah. When I figure out the other one, we could talk about it in September.
Sorry, I don't have those notes.
No, I don't have mine either. But I just wanted to brief everybody on it so that you knew what happened at that meeting. Anything else that we need to talk about? Judge Stewart.
Just a short question for Attorney Del Campo. Will we all receive the same version of the proposed rules on April 8th or whenever it is that they're transmitted?
Yes, I believe I do send them. They get packaged up a little differently because this 35 days before the public hearing is a little quick. So I usually give them a PDF version of you're going to see a little bit more cleaned up version, probably from Culp. But yes, I can send those out. Certainly, they should be the same unless somebody finds something along the way. But they're typically the same. Yeah, I can send those out to everybody. Sure.
Thank you.
Okay. Anything else? Let me thank you for all of your work thus far, and I will see you in person in May. So I'll accept a motion to adjourn. I'll take that as a motion from Judge McLaughlin. I saw the hand go up. Is there a second?
Second.
All right. It's been moved, seconded. All in favor, please raise your hand. That passes unanimously. Thanks very much, everyone. Have a great afternoon.
Take care. Bye-bye.
Thank you.